I have a basic will, life insurance, power of attorney, that kind of stuff. I have a simple estate, but I don't have an executor, this person's saying, which is very interesting. How do you have a will, but you never named an executor? I find that fascinating. And they said, what happens if I pass away and I don't have an executor listed in my estate plan? Well, somebody somewhere cares about your money, right? Whether it's your own family that they're saying, okay, mom and dad passed away, there's money just sitting there in a bank, let me go claim it. I'm their child, or I'm the next of kin. Or maybe you have a creditor, somebody you owe money to. Anyone that cares about your assets or your money that wants to make sure it gets passed down the right way, they're going to take your will and they're going to go to court and they're going to say, judge, here's this person's will. Here's your will. We want to get this authenticated so that we can move forward. The will doesn't name anyone as an executor, so I nominate myself, right? Anyone can go and open up a probate. Your creditors can, your family can, even your best friends can, you know? And when that happens, there's laws. The laws say who gets to be in charge of your estate. And if your will doesn't say who's in charge, then your trust can say it. If you don't have a trust, then there's state law that says who gets to be in charge first, who has priority over others. For instance, in California, when you're here and you either have a will or you don't have a will and no one's named as your executor, it'll start with your kids, or your surviving spouse will be first. If you don't have a surviving spouse, or if you're not married, then your children. If you don't have children, then it literally just goes back down the line of who is the most interested person in your family if you have no more heirs, right? And yeah, there are times where creditors open up probates for deceased people that either the family doesn't care or the deceased person doesn't have any family members that would take over. And the creditor ends up becoming the executor of the estate in order to sell off all the assets and get their debt paid back. Whoever does become the executor of an estate, they are taking on a fiduciary role. They are taking on a legal liability risk. So it is important that you choose someone that's going to have a little bit of financial literacy and is not totally an idiot. My recommendation is always to choose at least 3 people, nominate at least 3 people. There's like a law, statistical law of threes, where when you have 3 people listed on your will or your trust, chances are you're not going to have problems finding someone that will take over. But it's not required that you have an executor. The judge will appoint one. And if there's no one nominated and no one's stepping up to take priority, the judge is just going to hire an attorney to be the executor for you. And that attorney will get paid from your estate. And this stuff happens. This stuff happens all the time. So I do recommend you update your will and you put an executor on there, and then just let me know if you need help with that. My name is Yaasha Sabba. I work at Sky Unlimited Law, and this is what we do. We help with estate planning, asset protection, tax planning, long-term care planning, that kind of stuff. Thanks. Have a great day.